Our next speaker has graced this occasion, has managed to take out time from his schedule and grace the occasion all the way from Hyderabad. Ladies and gentlemen, please put your hands together for Dr. A.V. Narsimha Rao, Director, ICFAI Law School, Hyderabad.
Good afternoon to all the starwards of the dais and the students and professionals who are present here. First of all, let me thank BW, Mr. Anurag ji and Mr. Sudhakar, who has made this particular opportunity, who has given this opportunity to me, in fact. Professor Ranbir Singh has made the issue very easy to me because he has set up a tone about the legal education. So I had to continue thereafter with some other things only. When we talk about this corporates, one is most important is corporate social responsibility talk always. After a certain level of income generation, every company is supposed to spend some amount for the part of it. And as a part of that particular thing, they are coming with a different kind of schemes, creating a trust. Through their trust only, they are spending the money to the needy people. What kind of social responsibility the legal education institutions are having at present? Because legal education institutions have a great responsibility at the entire legal system. Judicial officers, lawyers, professionals, law firms are made by the legal education institutions. Law is the media, whereas the entire construction of that particular building, legal system is built by the legal education. If the legal education is not perfect, not strong enough, the building will collapse. That's what at present we are talking about. Whether are we creating the students or the professionals who are intellectually challenging and professionally relevant? Are we doing that? To that purpose, what are the activities, what are the level of efficiency and proficiency in the legal literature, legal arena has to be made? That's the biggest question we have. Just now we have been discussing about the Bar Council regulations and also 26 course or whatever that is made. Yes, there is a regulator to us, but even this regulator, to the extent, to what extent they are doing their job, let us forget about. They say we want the best professionals and we maintain the standards. For the purpose of maintaining the standards, we provide you some inputs. At the end of the day, we will be conducting one examination. Once the examination is over, we will allow them to enroll and they will be entering the profession. We have two different kinds of the people coming from our law schools, our legal education institutions. As our professor said, outcome-based education. One outcome will be the persons coming out of that will be the professionals, legal professionals, litigation practitioners. Second is academicians and also researchers, policy makers, administrators. These are the various things, various people coming out of our institutions. Okay, legal profession or litigants, once they enter into the profession, they may be learning depending upon the senior with whom they are working. There is a possibility of learning even after the legal education is over. For the purpose of educationist, or if they want to go as an academician, do the LLM and also PhD layer, do we have any academies to teach them? And do we have any kind of benchmarking or testing to find out whether that particular person who is coming out of the legal education, becoming academician, who is going to make the lawyers again and again in his hands, have the efficiency, or experience when they started, and whether his education or his approach to the legal education is changing according to the need of the time, according to the requirement of the industry, according to the requirement of international scenarios. Do we have that kind of benchmarking measurement? I think there is no. Research again, as professor said, okay, legal research is good at some of the national universities. What about those schools and colleges where there are no resources at all, and all those colleges which are there in the rural areas? Because I'm a part of the inspection committees of the Bar Council. We see many colleges in the rural areas and suburban areas. They don't have the infrastructure to sit. But it's inevitable because there the number of students are wanting or that area, there are no law schools. There is a requirement of starting law school in that area. Permission is granted. Faculties are not there. Infrastructure is not there. People joining maybe not having that kind of enthusiasm. Maybe they are joining with enthusiasm in the beginning. After some time, they'll be going out with a kind of sorry face, and they are going to become a legal professional at one point, and academicians other point, researcher third point. When they come out of that particular institutions, so-called affiliated colleges in the rural areas, they don't know about the online magazines, online databases. They don't know how to search, where to search, and what to search. If they are going to the advocate, their lifetime, maybe 10 years or 20 years, will be only with advocates carrying the files. Are we expecting this kind from our legal education, students of legal education? Then what to make it? And what kind of legal literacy we are imparting to the society, which is giving to us so many things? Are we talking about the value chain that is bestowed to the citizens, and which is the citizens are supposed to enjoy the value chain or values enshrined in the Constitution? Equity, equality, justice, and things. So these are the responsible legal education has. In order to do this kind of thing, we have almost 1,800 schools. Maybe first 100, 200 schools may be in a position to disseminate this kind of information to the people. But what about this? Do you want this legal has to be discard those, remove those schools or colleges? What is the per capita institutions for the people when we are tossing the 1.4 billion and the toppest population in the country? What kind of infrastructure the universities are providing, or the government is providing, or private organizations are providing to the people for learning? It is true, initially the law was taken as a last resort, but the things are changing. Now it is a choice. They have decided in the beginning only during school days, taken electives in CBSE or otherwise to go for the legal education. Lot of enthusiasm they are coming with. At the end of the day, when they don't get the seat in some selected colleges, they feel that their life is totally distorted. Can we say that not getting the seat or admission into some selected law colleges is the end of their legal education? Can we say the people in those institutions which are elated, whatever we call, are the only institutions? What we have to do to reduce the gaps in between these things? Unless the regulator, the government, educationist, philanthropist, all the people should come and discuss about how to reduce the gap. If you are reducing the gap in between the institutions which are offering legal education, automatically pressure will be reduced and the pleasure will be increasing up among the students. That's what we are requiring now. Let us see another side. Another side, there is a lot of mobility. People are going outside. Many people for the higher education, mostly for the PG education, they are going to outside. Why people are going outside the country? Do we feel that whether that country is providing the quality education than whatever we are providing? I don't think no. I don't think yes. And whatever the law they learn there, again they have to come here, complete some bridge course, or change their dimensions, approach, perceptions in order to practice in our course. The law which is they study outside may not be suitable to our law, our environment or our system. So again, they require to be changing at that particular part. When mobility is so much in the area of the education, second, mobility in the business. Many firms are coming to India. They are trying to adopt the systems which are there in India. And what are the problem? There is a cultural difference between them, that country and this country. There will be a lot of cultural shocks will be there when they do the business here. And what are the infrastructure that is available? And at the end of the day, when the infrastructure is put to use, what happens there? And initially we have very good infrastructure, but in course of practice, in course of usage, there will be a lot of problems they face. And the rectifications, corrections, plugging of those things will be a biggest problem. So under those circumstances, how we are going to answer? If you see the ease of business index, there are 3-4 important issues from legal side. That is enforcement of the contracts is one of the most important, which is contributing for the ease of business and which in turn will be attracting the investments to India. In turn, the growth of the economy will be there. Name of the country will be growing in that particular part. So one of the important is enforcement of the contract. Where it lies? In the hands of the professionals here, in the hands of the system, legal system here, in the hands of the judicial system here, in the system of alternative this alternative ADR method. We are talking about resolution. So these ADR methods, which were preferred early to the litigation, let us ask our own soul whether it is fulfilling its objective, whether the resolutions are completed within the time given or within the time expected. It is taking the time more than what the litigations are taking at one side. It is causing a lot of expenditure than what the real litigation takes place. These ADR methods are in the hands of some people, specialized people. It is not going out of that. So restricted accessibility to the resolutions again is the biggest problem we are talking about. Here also we are supposed legal education has to work about this particular part. When you are having a different class of litigations, are we able to make our students realize and attain the requirements of that particular part of it? Example, now we are talking about the artificial intelligence. We have seen the robo lawyers are coming to argue in the court of law. Chat GPs are providing information to the advocates. When chat GPs are providing information to the advocates or the judges, we have seen the fate in 2 or 3 cases, the wrong advices given by the chat GPs. How to realize that? How to counter them? How to identify them? Whether our legal education institutions are ready to make the challenge for that. Let us keep aside the artificial intelligence part of it and chat GPT. Whatever the cryptocurrencies which are taking place in the fintech era, whether the legal education institutions are ready to answer the queries and problems and complexities that are coming out of the cryptocurrencies. Simply one circular is passed by the RBI in the beginning that cryptocurrency is a digital one, so let us not accept. Not getting into the details. Again, our Supreme Court has intervened and give this particular part. And give that this is one. Now we are working upon that particular to give a law for that. We have the data sciences, data protection securities. When European countries already started their law, some of the countries in Western also have that one part of it. Australia is working for last 3 years. We have been working on that particular part, and we are not able to take unfortunate things, though we should not talk in the open forum. Most of the laws, whatever we are using it, is a traditional laws taken from the different part. It may be IBC, it may be GST, it may be old laws, we have been taken from different part of it. Application of our own intelligence, adapting them into our system, converting them into or customizing them into the requirements of the college, this particular area. We are not able to do it. Are we short of an intellectual capacities? We do have more intellect than the people who are doing that activity. Only here, there are 3-4 issues which will be stopping our path. One is bureaucratic red tapeism. Second is not having the encouragement. Third, some people are coming up that crab will be pulled by other crabs. There is matter. I do accept the statement of Professor Ranbir Singh, saying that, yes, Bar Council is given only 24 elects, all those things. There is no regulator which is stopping the law colleges by giving additional courses which are relevant to the day, which are required to go for the fresh in new areas of the business, new areas which are facing. Nobody is stopping them. They are only giving. Fine. And some of the things may be what many people are suggesting today is, let us go for the bilingual teaching, bilingual practicing. It's a welcome measure. There's no doubt about it. So even courts and all the people, even Bar Council is asking also for the bilingual English and also regional language, because we should have contact with the people at the local level. If we don't have the contact with the local people, maybe having the advocates that particular part, you may not be able to communicate whatever the client is expecting to the people. Under these circumstances, one more question is coming before us. Are we prepared? Are we prepared to teach the law in a bilingual way? If so, what kind of efforts we have to make it? We have to go for a resource development, building of the books, research has to be made, translation has to be made. This is a very big exercise again. Fine, we'll support the argument of the bilingual arguments, but the problems associated with the bilingual, we have to think first. Is it not? So legal education is a very, very good, because it is having a lot of social responsibility. We know very well that the lawyer is a social engineer. He transformed the society. We have seen history during your freedom fight. After that also, even every day we are seeing that the particular lawyer is a social engineer. Where is from where he is getting the instruments? Law is an instrument, and our legal education institutions are the buildings, designers of that particular part. Generally, we, other than 3-4 subjects, we teach only substantial law. We teach CPC, CRPC evidence. Are we teaching any kind of other procedure laws? Maybe those laws, those procedures which are embedded into the, along with substantial law. Not more than that. What is actually required for the practitioners? For the practitioner, general requirement is procedure. Substantial law, if he is able to understand the interpretation and the jurisprudence of that particular part, he can read and make. But procedures, that takes a lot of time in filing the cases and also dealing with. Many cases are dealt and what's called rejected for not following the procedures. Is it not? So client is not concerned with the procedure. He wants only justice at the end of the day. It is a professor, it is a professional, is supposed to know the procedure. When we are not teaching that practice part of that thing, then how will be learning? His learning will be not complete. So clinical way of teaching the subject, limiting your substantial law and increasing your clinical way. Example, you're talking about the contract law. Very simple. We talk about the sections also, 75 sections in the beginning, then we'll go for the special contracts apart. When we are having 75 sections, the legal education institution should work upon practical area. Example, drafting of the contracts. What are the main important classes in that particular contract which are required? What are the specific clauses which will be changing from one to the other? Of course, now draft contracts are available in the net. You can download, make the changes. Unfortunately, many of the known lawyers are not able to customize the formats which are available. In the beginning, the client will be he will be there. Suppose if the client will become she, in the body, that he will become only she. She will not be there, only he. They will not be changing the wordings. And all the terms which are not required ought to be deleted. That will all be. So general formats are being that, whether it is applicable or not. We are not able to apply our mindset for that. Under these circumstances, there is a need to change our perception about the legal education, first of all, our responsibilities and our objectives, and the way we undertake the legal education activity, that has to be changed. We should not be in the same well-designed old traditional molds. We have to come out of that. That mundane things we should come up. And let us satisfy the Bar Council by taking 24 papers or 30 papers, whatever it is, and you make the other papers, add papers of your choice, depending on the strength of your education institute. Need not be all people should take. If a particular legal education is associated a part of the engineering college, then you take the emerging technologies as a part of it. Use those people to come and teach part of that. And new education policies also talk of the multidisciplinary angle. Though new educational policy 2020 talks of the multidisciplinary path, the legal education department from 2008 itself is teaching the multidisciplinary approach part of it. We have the BBA, we have BA, BSc, BTech, so many combinations are coming and we are teaching them. Is it not? So for all the purposes, legal education is ahead of all the part of it. But only one thing is, we have to pinpoint, to focus the areas where we should work upon. And we should not make the people for job purpose. We should be preparing our students as a market-ready students to take challenges of any kind, whether it may be litigation, it may be education, or it may be a profession, it may be research. So different kind of angles, you can make it. I'm sure everyone is using the internship for that particular purpose. The internships, clinical legal education are going to make a lot of change in the minds of the people, which is decided for the legal education part of it. Okay? She's waiting for me to stop. Thank you very much. A lot of things we can discuss across, but time is the limit. Thank you very much.
Well, Dr. Rao, thank you very much for a very interesting session.